Good morning, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. We're here in docket number 2021-153S. Please join me in a brief moment of silence. All right, President, in the hearing room we have Commissioner J. Williams, Caston, Powers, Belzer, C. Williams, and joining us virtually we have Commissioner Thomas. Attorney Butler, if you would, please read the docket.
Yes, thank you, Mr. Chairman and other members of the commission. Good morning. As you stated, this is docket number 2021-153S, the application of Palmetto Wastewater Reclamation, LLC, for adjustment of rates and charges for the provision of sewer service and modifications to certain terms and conditions of its service. In order for testimony to be received from all parties, the commission has scheduled a hearing to begin at 10 a.m. on Wednesday, November 10th, 2021, both virtually and in the offices of the commission. Mr. Chairman and other members of the commission, the docket is in order.
All right, thank you, sir. Let's recognize the parties. Applicant.
Charlie Terani for the applicant, Mr. Chairman.
All right, let's recognize the interveners. South Carolina Department of Consumer Affairs.
Good morning, Mr. Chairman. Appearing virtually, obviously, Roger Hall, Deputy Consumer Advocate with the department, and also Connor Parker, Assistant Consumer Advocate.
All right, Office of Regulatory Staff.
Chris Huber here for ORS along with Nicole.
Sorry, Mr. Chairman. Good morning, Mr. Chairman. Chris Huber here for ORS along with Nicole Hare.
All right.
And I have one preliminary matter whenever the appropriate time is.
Okay, we'll get to it. We'll get to it. Before we get to your preliminary matter, there's one that we need to take care of from the commissioners. Commissioner Caston.
Thank you, Chair Williams, and I just wanted to read a statement just for the record. I want to state for the record, I worked as a consultant for Goodwin Mills and Kaywood, GMC, and Clearwater Services in the water and wastewater industry from April 2019 to September 2020. I had the opportunity to meet with Mr. Craig Sorensen and other company personnel for purposes of the solicitation of consulting business. As it happened, my discussion did not result in any work from the utility being performed by GMC or Clearwater Services during my consulting time on behalf of GMC and Clearwater Services. No further business solicitations have taken place. I do not have any personal bias or prejudice concerning any party, and I do not have any personal knowledge of any disputed evidentiary facts in this docket. I have no economic interest in any party. I ensure everyone I can be impartial. However, I wanted to make these contacts known so that the parties in the case would have the opportunity to object to my participation. If there is no objection, I'd like to continue to serve as a commissioner on this matter.
Okay, thank you for sharing, Commissioner Caston. Attorney Elliott.
Yes, sir, Mr. Chairman. We feel that it's Commissioner Caston's extensive work background that qualifies him for service on this commission. We do not see a conflict, but out of an abundance of caution, we will, for the record, waive any conflict that might exist. We are happy for Commissioner Caston to participate.
All right, thank you, sir. Office of Regulatory Staff.
No objection from ORS to Commissioner Caston sitting for this matter. Thank you.
All right. Consumer Advocate.
Likewise, we have no objections. Thank you.
All right. Mr. Attorney Terani, do you have anything you want to put on the record, or is Mr. Elliott's statement good enough?
For us, we're split up, Mr. Chairman.
Okay.
We'll fix that after.
Yeah, we definitely need to fix that. I'm thinking you with the Office of Regulatory Staff over there.
It's an odd place to be.
All right. Attorney Huber.
Mr. Chairman, is it okay if I approach the podium?
Yes, sir.
Mr. Chairman, if I may, while Mr. Huber is going toward the podium, There's one other thing I would like to add for the record. In accordance with the CJC, Special Counsel Butler and myself did meet with the parties outside the presence of the commission and did discuss the disclosure of the contacts with regard to what Commissioner Caston did previously just disclose. And as parties reported, there was no issue.
All right, thank you, ma'am.
Thank you, Mr. Chairman and members of the commission. My brief preliminary matter is the parties have entered into a partial stipulation, and I call it partial, but the stipulation resolves all issues among the parties with the exception of return on equity. And if it pleases the commission, I can give a brief summary of some of the terms in the stipulation.
Absolutely.
As part of the stipulation, the parties agree to almost all of the recommended adjustments and customer protections in ORS testimony. These include adjustments related to allocation of corporate overhead and shared costs. Parties have agreed to rate case expenses of $160,000 being amortized over 3 years. The parties have agreed to the various revenue adjustments proposed by ORS based on customer and equivalent residential customers as of the end of August 2021. The parties have agreed to certain ratepayer protections described in ORS witness Garrett's testimony. He describes it as ring fencing provisions. The parties, as part of the agreement, did agree to amend an adjustment to allow PWR recovery of additional $14,336 in chemical expense. And as far as the cost of capital issues besides ROE, the parties agreed to a capital structure of the company that includes 45% debt and 55% equity. And the parties agreed to a cost of debt for the company of 3.79%. There are also various provisions related to changes in the tariff in the stipulation. I certainly defer to the chairman as far as whether the commission would like to take the stipulation under advisement during the hearing. There is one portion of the stipulation, in particular, the parties would request the commission to consider. As part of the stipulation, we agree to stipulate certain witnesses, not all of our witnesses. As for ORS, we were requesting that Ms. Tina Seal's testimony be stipulated in without her appearing, but Mr. Hanel and Mr. Garrett would still appear and testify. I don't want to speak for the other parties as far as their request on that issue, but Mr. Elliott, Mr. Tree, did you have a request regarding either of your witnesses?
With respect to the stipulation, we propose to stipulate the testimony of Mr. Burkett and of Mr. Hafiz. The issues testified to in their pre-file testimony have been resolved by the partial settlement. That said, Mr. Hafiz is available. If you would like to hear from him, we would just simply tender him for commissioner questions. An issue has arisen that I've made council aware of. Mr. Burkett is out of the country and unavailable to testify. We propose to substitute Philip Williams to adopt his testimony. Mr. Williams is a CPA, practices in Mr. Burkett's practice, and was actively participated in the preparation of the schedules and the application in this case. Mr. Williams, frankly, without embarrassing him, might have more detailed knowledge of the schedules than would Mr. Burkett, and I think for that reason would prove to be a more satisfactory witness if you chose to hear from Mr. Williams at all. So our request would be that Mr. Williams be permitted to adopt the testimony of Mr. Burkett if Mr. Burkett's testimony is not stipulated in without questions, and we would tender Mr. Williams for questions to the commissioner instead of Mr. Burkett. I understand all counsel are content and have no objection to this process.
And just before I don't know if the DCA has any comments, but quickly, I'd like to add, Ms. Seal, certainly the commission would like her to be here for commissioner questions. She is available. And there is one more provision to the stipulation I should have mentioned, but there's a 18-month stay out period as part of the stipulation such that no new rates would go into effect until 24 months after the order in this proceeding.
That's correct.
Okay. Now, can Ms. Seal testify virtually? When you said she can appear, were you referencing in person, or is she available in her office?
She can testify in person. The plan would still be for her to be on a panel with Mr. Hunnell if the commission would like to hear from her.
Okay. All right.
Mr. Chairman, may I ask a question?
Yes, ma'am. Vice Chair Belzer.
Looking at the list of witnesses on page 3 of 11 of this partial stipulation that I think y'all are asking to stipulate the testimony in, those witnesses are testifying to the accounting adjustments which have been agreed to, or well, basically most of the accounting adjustments. Is that correct?
Yes, ma'am.
So the issues that they address have been addressed by the partial stipulation. Is that correct?
Yes, ma'am.
That's
in fact, in Mr. Burkett's case, he raises a question in his rebuttal testimony that all credit to the Department of Consumer Affairs, their witness evaluated and acceded to in his surrebuttal. So, most of Mr. Burkett's surrebuttal testimony has been acceded to in pre-file testimony on the record.
Thank you.
Yes, ma'am.
That's correct, Madam Vice Chair. Really, the witnesses left are testifying on the return on equity. That they're witnesses that testify on the return on equity issues.
All right. Well, look, gentlemen, I appreciate your comments regarding the stipulation and making your witnesses available. I want to ask my fellow commissioners this. Are there questions for the witnesses whose testimony has been stipulated to?
Mr. Chairman, Commissioner Thomas.
Yes, sir.
I have one question, and I'm not sure it's really related to the question you just asked, but also, I appreciate that we have a stipulation in front of us, and not real sure how to ask a question sometimes when you have a stipulation that doesn't upset the apple cart. But so what the only thing I'm thinking about right now is we have a rate case expense of $160,000 that has been agreed to with a 3-year amortization period, and then a agreement stay out for 18 months. And I know that we have seen at least one incident in the past where rate case expenses, when you put a kind of a lump sum number in there, and it can get kind of tricky when you come back in what was included in that lump sum number versus what has been recorded as the actual expenses. And I guess my thought there is there, something that can keep that from becoming a problem at the next rate case? Don't know who to ask that of, but that's pretty much my own concern.
Good question, Commissioner Thomas. The practice with respect to rate case expenses, attorney's fees, costs, and that sort of thing, is that the applicant, and in this case PWR, must tender its billing, its attorney's fee billing, to the Office of Regulatory Staff for review. They review it for reasonableness and accuracy, and then they will take a position as to whether or not the amount tendered is reasonable. That said, we've agreed to cap it at $160,000. We may or may not reach that cap, but before any recovery of those attorney's fees, say, will be authorized, the ORS will weigh in on whether or not the expenses were accurate, reasonable, pertaining to this docket. And so there will be a record, a regulatory record of the expenses that would be covered by any order in this case.
Okay, thank you. I appreciate that.
Mr. Chairman, may I weigh in on that?
Vice Chair Belzer, yes, you may.
Years ago, and I really, we keep hearing this is the way it's been done and this is the way we're doing it. But years ago, there would be an exhibit before the commission on rate case expenses, include, whether it was the bills or redacted, if they contained information that was deemed attorney-client privilege. But we had, the commission had something in the record. What has transpired over the years really troubles me, because this practice that has been allowed of submitting rate case expenses to ORS after the hearing, there's nothing in the record to support these adjustments sometimes. And I think this is something that the parties need to look at, because there needs to be an evidentiary basis before the commission. Granted, ORS does a good job. I'll say they do a good job of looking at these expenses, but those materials need to be before this commission for an evidentiary record to support any recovery of those rate case expenses. And I think that's something that the parties need to look at and perhaps revise what has become custom.
We will accede to any requirement imposed by this commission. I might add that the way, at least the way we have been doing it over the last 15, 20 years, it does allow for us to disclose, I think, a sufficient amount of information for the ORS auditors to determine that what these costs were for, who the call was made to, who the email was sent to, what memo or brief was prepared and billed for. And so, to your point, I think I would, as a practitioner, while I'd be content to accede to your suggestion, my bills might be a little more redacted than they might be if I thought that they were simply going to the ORS for them to sign off on.
Yeah, but you just pointed out that the ORS is signing off on it, and then we're just basically signing off on the ORS, and we're not getting the detail of what the adjustment is. And it's not only rate case expenses, Mr. Elliott. I mean, it happens a good bit, and I've been troubled by this before I even became a commissioner, that there is nothing in the record really to support some of these adjustments. Same thing is when somebody says something about, well, I'm making this adjustment based on a discovery request. Well, we don't know what the discovery request said. The basis is just not there for us sometimes.
We are here to accede to the order of this commission.
If I may just respond briefly, I mean, ORS, the practice recently in recent years has been to allow updates to rate case expenses through the hearing up until the proposed order. Simply, I think it's sort of a unique expense because the company is incurring those expenses up through the hearing, and but ORS is certainly glad to, certainly will review the updates the company provides and verify the updates the company provides. That's something our audit department customarily does.
And I understand that, Mr. Huber, but my point is there is a hole in the record before this commission for the basis of these. I mean, it's the company gives a number, ORS gives a number, the CA gives a number. We don't have anything to base that the number is correct, and it's not just rate case expenses. This is. Well,
I might suggest that the commission require us to file them under seal. I mean, that's
fine. That used to be that was the practice a long time ago.
Again, the concern, the sole concern as a practitioner would be not to disclose an attorney-client privilege. It was unnecessary to your ability to determine that it's a proper, relevant.
Well, what if let me just throw, this is the problem. What if there's a dispute and ORS says, well, we don't think this ought to be allowed, and the company says, we think this should be allowed. We have no basis on which to resolve that dispute. That's my concern.
Well, I mean, we have had disputes with ORS over attorney's fees and with respect to other clients, not this one. And generally, they tend to get resolved, but it says green. But again, I mean, I think filing these matters, serving on the ORS, filing them under seal, letting the ORS report to you their findings. I mean, I think that addresses your concerns. I mean, it's well taken.
I think it does.
Shall we just plan to do that, Mr. Chairman?
Well, that's what I was thinking about that. Vice Chair Belzer, is that what you want to happen in this case? Or were you just making the point generally?
I think it needs to happen in this case and in future cases. And granted, these are very few parties here, but this has just gotten to be, I think we've gotten away from cases and the regs following the rules of evidence to, well, this is what we got, this is what we did last case, so it's not just y'all. This is a I will say in quotes, problem that I have observed for quite a number of years, even before I got here.
Chairman Williams.
Okay. Oh, 1 second. So, what's the path forward? Are you all prepared to introduce what Vice Chair Belzer requests under seal?
Yes, sir.
Okay.
And Mr. Chairman, excuse me, Mr. Huber, they are correct. These used to be filed as a late filed exhibit because the hearings do take a good bit of time, and the company is incurring those expenses, and through the hearing and even after the hearing, and so that's why it was allowed to come in as a late filed exhibit. As much as I'm not a fan of late filed exhibits, but to be fair, that's why they came in, is my understanding, so that the company, not just this one, but got coverage through the hearing and even post-hearing work. So,
All right.
but there does need to be a cutoff date at some point.
Yes, ma'am.
Understood. All right. Do the parties understand what Vice Chair Belzer is requesting?
Yes, Mr. Chairman.
Okay.
Yes, Mr. Chairman.
Our agreement is that we will tender the updated attorney's fees to the ORS for their review, but sort of at the same time, we will file the attorney's fees submitted from the outset of this hearing through that date with the commission under seal, redacted sufficiently to protect the attorney-client confidence, but to allow y'all, if you care to read them, to understand what the work was done for.
All right. Vice Chair Belzer, does that meet your intent?
Yes, Mr. Chairman. I just want to make sure that the record supports what may be awarded in what may or may not be awarded in the case.
And that absolutely satisfies Commissioner Thomas's concern.
All right.
Because
Roger
there'll be
that.
a record.
All right. Attorney Huber, do you want to offer in the stipulation as a hearing exhibit?
Yes, so what I was about to ask for that. If I could, I would have, rate case expenses does include attorney fees. I did want to mention it also includes consultant fees and other similar expenses. But yes, we would like to offer the stipulation as the hearing exhibit.
All right. So ORS, well, the party's stipulation will be marked to enter into the record as hearing exhibit number 2, and we will reserve a late filed exhibit, hearing exhibit 3, for all rate case expenses, and they will be filed under seal.
Yes, Mr. Chairman. As far as the question of excusing certain witnesses and allowing their testimony to be stipulated in without them appearing. Is that something the commission is taking under advisement, or?
We'll get there. We'll
Okay.
get there. Commissioner Caston, you had a question?
No, sir, not so much a question as a statement, something Vice Chair Belzer said that kind of triggered a thought. As obviously a relatively new commissioner, and in other hearings, I know on more than one occasion, I have heard something along those lines is kind of the way we've always done it, which that implies since the beginning of time, and I don't think that's accurate, but nonetheless. I don't know how things were always done, but it's just a matter of, I guess, experience, past, and everything else. Is I've observed it's very easy to not just fall into a rut, but I call it a fur-lined rut. It feels so good. Why do you want to get out of it? So the only reason, or the only thing I'm offering or suggesting is that it's good to look at what we've done, and if it needs to continue to be done that way, we should. But just because we've always done it that way doesn't mean that's the way we always need to do it. Let's try to do it better. So that was the only comment I had for what it's worth. Thank you, Mr. Chair.
All right, thank you, Commissioner Caston. So the parties that offered a stipulation into the record, they have testimony that has been stipulated to, and I think their request is for the witnesses whose testimony has been stipulated to be excused from this proceeding, and that we hear from the witnesses whose testimony has not been stipulated to. My concern regarding that is if we excuse those witnesses, we will only have the stipulation to stand on to make our decision in this case, and I do not want to limit the opportunity for commissioners to ask questions if you have them. Now, if you don't have the questions, then it raises a question of judicial efficiency as to whether or not we need to hear from those witnesses. So my question to my fellow commissioners is whether or not you have questions for the witnesses that the parties stipulated to. Vice Chair Belzer.
I think I can get clarification from council on this, and I don't know, it's just something that came to mind. The stipulation limits the rate case expenses of this docket to $160,000. Is that correct? But there are also some unrecovered expenses from the prior rate case. My recollection is like 26,000 or something like that.
I think those have now been recovered. Yes, ma'am. Those have now been recovered in current rates.
Okay, thank you. With the qualification of the expenses, the late file exhibit, Mr. Chairman, I don't think I have any questions for these witnesses who are listed. Thank you.
All right, thank you, Vice Chair Belzer. So, parties, if you would, for the commission's sake, go through the witnesses' testimony that's been stipulated to. Attorney Huber or Attorney Elliott.
I'm glad to do so, Mr. Chairman. The witness for ORS that we requested to be stipulated in without her appearing is Miss Christina Seal. For the DCA, and I'm sure Mr. Hall will correct me if I'm wrong, Lafayette Morgan has been requested to be stipulated in without him appearing. And then for PWR, the two witnesses are Mujib Hafiz and Philip Williams. And just for clarification, I know it's on the stipulation, it's got Daniel Hanel there, but basically Daniel Hanel still will appear for commissioner questions. The parties just agreed to stipulate to waive cross-examination of him.
Okay. So Philip Williams for the applicant, Lafayette Morgan for the intervener, the South Carolina Department of Consumer Affairs, and for the Office of Regulatory Staff, Ms. Seal. Now,
Mr. Chairman.
Okay. Yes,
And
sir.
also, Mujib Hafiz, we've asked to
Mujib.
stipulate his testimony in.
Mujib Hafiz.
Yes, sir.
Thank you, sir. Commissioners, do you have questions for the listed witnesses? All right, so it appears that the commissioners do not have questions for the witnesses' testimony that the parties stipulated to. Those witnesses are excused.
Mr. Chairman, may I ask one question?
Yes, ma'am.
My understanding from the stipulation is that, can we say all of ORS's adjustments have been accept? Where I'm getting at is, there is no, comprehensive, exhibit or operating experience, rate base and rate of return, exhibit attached to the stipulation, is there? And I don't know if, Ms. Seals Exhibit 1 or Ms. Seals Exhibit 7, is that still current?
You're correct, Madam Vice Chair. There is no exhibit, and part of the reason is the fact that the return on equity is still
Right.
outstanding, so we're not able to calculate the revenue requirement or the rates because of that. I will say that under the stipulation, the parties have agreed to all of ORS's adjustment except for any that are listed below
Right.
that in paragraph 4.
Okay.
But sure.
That answers my question, Mr. Huber. Thank you very much.
Thank you.
All right. So now that that has been taken care of, the witness list as I see it now is Paul Moole. Is that how you say that? Mao. Okay. Paul Mao.
We're gonna call Craig.
And Craig, I'm just going down. Not. This is not in the order of appearance.
Oh, okay.
Craig Sorensen, Aaron Rothschild, David Garrett, Daniel Hanel, and that's it, right?
Yes, Mr. Chairman.
All right,
David.
and then Mr. Sorensen will be the first witness.
Yes, sir.
Then Mr. Mao. Then Mr. Rothschild. Then Mr. Garrett. And finally, Mr. Hanel. Is that correct?
Yes, sir.
Yes, sir.
All right. So here's how the rest of the day is going to play out. We're going to break for lunch at 11:45. We're going to come back at 1, and then we're going to break at 3:45, and that's how we will end the day. All right. Any question about that? No questions. All
Thank
right.
you, Mr. Chairman.
All right, applicant, please call your first witness.
Excuse me, Mr. Chairman.
Yes, sir.
Yeah. I'm sorry, I did have one other preliminary matter.
Okay, please go right ahead.
Yeah, again, Roger Hall with the Department of Consumer Affairs. And I will defer to you. This may be more appropriate to raise when PWR does put up its witnesses, but I felt that I needed to mention it now. Yesterday afternoon, PWR filed what it termed as corrected rebuttal testimony of Mr. Sorensen. With the exception of one addition regarding a consent order, I do not believe these are actually corrections. Otherwise, it appears to really simply be a striking of its own testimony that it no longer wants on the record. And therefore, I would object to those items being changed. The testimony in question has been responded to by DCA witness Rothschild and OR witness Garrett, who created additional tables in a surrebuttal based on it. If PWR is allowed to remove that testimony, then I don't see what would stop them from arguing that Mr. Garrett's testimony is not surrebuttal of the issues in rebuttal. Mr. Sorensen presumably believed that these statements were true at the time he filed them. I believe if he wishes to change his opinion or statements, then I suppose he could do that during the normal course of submitting a testimony. However, I do believe striking it completely as if it were never spoken is highly inappropriate, and I feel it's an abuse of the procedures the commission has established for making corrections. Therefore, I would like to object to the striking of the testimony of Mr. Sorensen's corrected rebuttal.
All right, just so I understand the basis of your objection, you're objecting to a party withdrawing testimony because it's an abuse of the commission's established procedure?
Yes, and I also believe the commission regulations submit that witnesses pre-file their testimony to the extent possible. And the third, I guess, objection would be that this testimony has been responded to by one of our witnesses as well as ORS's witness.
Attorney Torini?
Mr. Chairman, no deed goes unpunished. We had withdrawn questions in Mr. Sorensen's testimony, anticipating that it might be objected to as beyond the scope of his testimony. We think he's qualified to give it. We'd be delighted for him to give it if he wants to. As to the procedural objections that were raised, I don't think they're valid. Testimony is only introduced when it's adopted on the stand. We haven't supplemented his testimony. We've merely taken things out of his testimony. So it's not like Mr. Hall's been surprised by this. We just simply withdrew matters that he decided not to adopt on the stand. And I've always understood that until you rule that that testimony is an evidence as if given orally from the stand, that's how it works. And I think the precedent of saying a witness can't amend his testimony before he adopts it is really dangerous for this commission, not particularly for my case, but for this commission.
And Mr. Chairman, if I might add, again, I'm not saying that he can't amend it from the stand if he wishes to, but to file it as if it was never said, that's one thing. That's a completely different thing. So if he changes his mind and now will redact it, but again, I don't believe ORS is withdrawing their witnesses' testimony related to it. DCA certainly does not plan to withdraw our testimony related to it. And so it simply wouldn't make sense. We have surrebuttal testimony referencing rebuttal that will now no longer be part of the record.
Just one point.
Yes, sir.
It was never said. It's not said until he comes in here and adopts his testimony. Now, if it simplifies things, we're not going to object to the rebuttal testimony that's being offered.
Okay, well.
Mr. Chairman, may I respond briefly for ORS?
Yes.
We do agree with the DCA on this point about the amended, I'd call it amended rebuttal that was filed yesterday for Mr. Sorensen. The DCA and ORS did file responsive testimony to the original rebuttal that Mr. Sorensen filed. So we do agree with the DCA's objection.
So I do not. I mean, the testimony is not spoken until it's entered into the record. Honestly, the objection is a bit confusing to me. I'm hoping I'm understanding the issue correctly, but that pre-filed testimony can be withdrawn or changed before it's entered into the record. I'm not aware of any rule that would prohibit that. I mean,
and Mr. Chairman, with all due respect, as long as we can, if there's no objection to the surrebuttal testimony that responds to it, that now will respond to something that was never said, as long as that is still part of the record, then much of my concerns will be alleviated.
Mr. Chairman, ORS is not planning to correct its surrebuttal. So I know that's what Mr. Hall is referring to. I will say ORS is not planning to change its surrebuttal that it filed.
Okay.
But also that Mr. Torini appears to have agreed that he will not object to statements that in surrebuttal that are essentially no longer applicable to testimony from Mr. Sorensen.
Okay. All right. Well, we'll cross that bridge when we get there. At this point, your objection is overruled. Is there anything else? If there's nothing else, Mr. Torini, would you please call your first witness?
Yes, the applicant calls Craig Sorensen.
Mr. Sorensen, if you would take the stand and pause to be sworn in by our court reporter.
we've got two. If you would go ahead and be seated, Mr. Sorensen. And if you would raise your right hand when you're ready. Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Sorensen, please state your name and business address for the record, please.
Thank you. My name is Craig Sorensen, and my business address is 1710 Wood Creek Farms Road, Elgin, South Carolina, 29045.
Mr. Sorensen, did you prepare or cause to be prepared 4 pages of direct testimony pre-filed in this docket?
I did.
Do you have any additions or corrections to your testimony?
I do not.
If I asked you the questions in your pre-filed direct testimony, would your answers be the same?
They would.
Mr. Chairman, I move the pre-filed direct testimony of Craig Sorensen be moved into evidence as if given orally from the stand.
The pre-filed direct testimony of Craig Sorensen will be entered into the record as if given orally from the stand.
Mr. Sorensen, did you prepare or cause to be prepared 8 pages of rebuttal testimony pre-filed in this docket?
I did.
And did you file a corrected or revised testimony in this docket yesterday?
I did.
Are there changes reflected in the 8 pages of your revised, are your changes to your testimony reflected in the filing made yesterday?
They are.
Do you have any other changes you wish to make to your rebuttal testimony?
I do not.
If I asked you the questions in your pre-filed rebuttal testimony as of yesterday, would your answers be the same?
They would.
Mr. Chairman, I move to the pre-filed rebuttal testimony of Craig Sorensen be moved into evidence as if given orally from the stand.
The corrected pre-filed rebuttal testimony of Mr. Craig Sorensen will be entered into the record as if given orally from the stand.
Mr. Sorensen, what's your current position?
I'm president of Southwest Water Company's businesses in Alabama, Florida, and South Carolina. And for this proceeding, I am also president of Palmetto Wastewater Reclamation.
You wear several hats.
I do.
Please tell the commission about your educational and professional background.
I have a Bachelor of Science degree in mining engineering from the University of Missouri-Rolla and a Master of Business Administration from Samford University. I'm a licensed professional engineer registered in 4 states, including South Carolina, and have over 25 years experience in the water and wastewater industry, from construction to design engineering to facility management, ownership, and operations.
Now, Mr. Sorensen, PWR is a bit of a mouthful, so can we just refer to the company as Palmetto?
I'm fine with that.
And can you tell the commission why Palmetto needs to raise its rates?
Palmetto's current rates were last approved in May of 2019 and were based on a test year ending August 31 of 2018, which is now over 3 years old. We need to adjust rates so that Palmetto can provide adequate service to its customers, to meet its expenses, and be permitted the chance to earn a reasonable return on its investment, attract future capital, and comply with the standards promulgated by DHEC, US EPA, and other regulatory agencies.
Has Palmetto made capital improvements to its system since its last rate case?
It has, and we've made several, and I'll describe a few of them, starting with
Please.
safety-related items. First, Palmetto worked with DHEC to change the disinfection process at the facility and moved from using gaseous chlorine for disinfection to using liquid chlorine for disinfection. This change is equally effective, but greatly reduces risk to the community in the event of an equipment malfunction or a line leak. We also made several safety improvements at the facility, from increasing security to addressing fall hazards, new ladders, handrails, and even a concrete barrier to keep vehicular traffic and others from falling into the ground level oxidation ditch. We've replaced effluent pumps, rebuilt 6 of the plant's floating brush aerators, replaced the trailer that houses the lab and operator workstation, and also performed general plant maintenance items. In the collection system, we invested capital and replaced about 2,500 linear feet of gravity sewer line along Piney Grove Road, and also 140 feet of sewer main trunk sewer line that was on the bank of Stoop Creek and had eroded due to natural processes and needed to be replaced.
Mr. Sorensen, I'd now like to turn to your rebuttal testimony. What is Palmetto's requested return on equity?
Palmetto is requesting a return on equity of 10.95%, which is supported by our expert witness, Paul Mowell.
And what was the return on equity recommended for Palmetto by the Department of Consumer Affairs and ORS's expert witnesses? Do you know?
I do. Mr. Rothschild, on behalf of the Department of Consumer Affairs, recommended an ROE of 7.31%, and Mr. Garrett, with ORS, on behalf of ORS, recommended an ROE of 8.90.
Do you know what Mr. Garrett and Mr. Rothschild have recommended as ROEs in for other utilities in South Carolina?
Based on the engagements listed on his website, I'm not sure that Mr. Garrett has provided any testimony regarding cost of capital in South Carolina. Mr. Rothschild appears to have provided cost of capital testimony in South Carolina recently for the rate cases at Dominion Energy, South Carolina, Palmetto Utilities, Inc., and Blue Granite Water Company. And in those three cases, Mr. Rothschild recommended ROEs of 8.63%, 8.63%, and 8.65%, respectively.
And do you know what ROEs have recently been granted by regulatory authorities to Palmetto and to Palmetto's affiliates in South Carolina and in other jurisdictions?
I do, and I've included a table in my testimony that shows what those ROEs are. And I would like to note that each return granted across multiple states and multiple jurisdictions is at least 9% or more. And I can go through the table.
Please do.
And address each one. In Texas, working most recent to further back, in Texas, the commission there awarded our affiliate an ROE of 9.0%. The Florida Commission has a range of ROEs that they grant based upon capital structure. And if you assume the capital structure of 50% equity, that would give us an ROE of 9.65%. The Oregon Commission has weighed in and authorized our affiliate to the opportunity to earn a 9.50% in Klein Butte, a 9.50% in Mountain Lakes, and then this body has allowed Palmetto Utilities, now South Carolina Water Utilities -PUI, the opportunity to earn a 9.07%. And this utility itself, Palmetto Wastewater Reclamation, currently has the opportunity to earn a 9.93% ROE. Our California affiliate has the opportunity to earn a 9.25% ROE, and should, just as a point of reference, it also, the California Commission authorizes a forward-looking test year and approved capital plans in advance of the spend.
Why are these ROEs that you've just told the commission about that were given in other proceedings relevant to this proceeding, in your opinion?
Well, given the same level of risk, investors will obviously invest their money in locations where they can earn higher returns. And if the commission were to adopt either Mr. Garrett's or Mr. Rothschild's recommendation and award Palmetto a lower ROE than we're granted in our other jurisdictions, it would put Palmetto at a distinct disadvantage in attracting the capital necessary to operate, maintain, improve, expand its system, and ultimately, I believe, harm its customers.
Mr. Sorensen, do Palmetto and Southwest Water share a mission statement?
Yes, that statement is that we take pride in providing safe and reliable water, wastewater services, and resource management for homes, businesses, and communities nationwide.
And do you have shared values?
We do. Those values are job safety, stewardship of the environment, customer care, employee success, and community citizenship.
Can you tell the commission how Palmetto has lived up to these values?
I can, and I would say that it was important to me that the utility do, so I moved my family here to lead the business, boots on the ground, to ensure that the company does meet those, uphold those values. Safety, Palmetto has had 0 recordable or lost time incidents since its last filing. And for point of reference, it's been about 4.5 years since anyone in my group has had a lost time incident. Environmental stewardship, Palmetto has improved its environmental impact through the investment in its facilities of approximately $2 million, which has resulted in system improvements that I've mentioned previously, as well as the closing out of 2 NOVs and a consent order related to issues that occurred prior to its acquisition by Southwest.
How about customer care?
Customer care is a focal point of Palmetto. We've implemented, after I moved here, we implemented an organizational restructure where I moved customer care from reporting up through the accounting department, and instead they now report directly to me as the president of the business. We hold regular scheduled and unscheduled meetings to discuss potential customer services issues quickly and work to resolve them as efficiently as possible. And I'd like to say that this emphasis has shown itself so far this year in that we've only received 2 customer complaints, both of which were quickly resolved. Only 1 customer spoke at the public hearing earlier this week, and she had no complaint about our service levels. Her complaint was largely around the pricing, and thankfully for her, we already have some of the lowest rates in the area.
You said only 1 customer. There were several people that spoke. Have you had an opportunity to determine if they were your customers?
There were several people that signed up and have filed letters of protest. Going through the list, I believe we feel that only 1 other customer that filed notice was a PWR Palmetto customer. The others are, I believe, either Palmetto Utilities customers or Richland County customers, or are generally unknown to us. There was an article that came out, I think, late last week that had a misleading headline. The article wasn't written very clearly as well, and so I think that's created some confusion.
Who was the customer that did speak? Do you have her name?
Her name was Hattie Barnett.
Okay. And going back to your values, how have you encouraged the success of your employees?
Yeah, employee success is something we focus on. Employees are critical to our company and to our customers. We want to grow and develop them and give them opportunities to advance along the way. And as part of that vision that we have, it's an expectation that each employee, for example, would take annual training on whatever subject would help them in their particular role or a role that they want to develop in, and that the expectation would be that every employee, not just those certified or registered or have some professional designation and requirement for continuing education, but every employee would have 14 hours of personal development training every year.
And finally, how is Palmetto active in the community?
So as a utility provider, we are already immersed in the community. And I believe that as the utility and our central role in the community, that should hold us to a higher standard as a utility. And so we should be active in our communities beyond the work day. And I'm proud to report that in spite of COVID restrictions, our South Carolina employees have logged over 300 volunteer hours so far this year and engaged in various activities that were important to those employees, from highway cleanups, Habitat for Humanity, home building, and I think there were some, pet agencies, those sorts of things, and then we're also continuing to plan more events in the remainder of the year, supporting causes such as Meals on Wheels and the Leukemia and Lymphoma Society.
Thank you, Mr. Sorensen. Please answer any questions the parties or the commissioners may have for you.
Thank you. Sorry, is that better? Thank you, sorry.
Is there any cross-examination for Mr. Sorensen?
Yes, Mr. Chairman, Roger Hall, Department of Consumer Affairs.
Mr. Hall, go right ahead, sir.
Thank you. Good morning, Mr. Sorensen. How are you?
Fine, Mr. Hall, how are you?
I'm doing well. So just as a side note, this oftentimes the commission we like to they like to talk about which colleges folks went to, and I just want to say that I'm went to Cumberland School of Law, and I got a master's from Samford. So I think you might be the first other Samford grad that's appeared before the commission.
Go Bulldogs.
So you've been president of PWR since 2006, is that correct?
I've been president of PWR since late last year.
Oh, okay. Have you testified in any rate cases previously?
I have. I've testified for our affiliate at Kiowa Island.
Is that the only other time you've testified?
That's the only other utility I've testified for. I've testified on behalf of Kiowa more than once.
And you're an engineer. Have you testified regarding engineering issues previously?
I've not.
Have you ever been qualified as an expert when you testified?
I've not.
And so, sir, obviously not as a rate of return expert either then.
That is correct.
Did you assist in preparing the application for this case?
I did.
And are you generally familiar with the current tariff provisions?
Generally.
And are you generally familiar with the commission regulations regarding PWR's operations?
Generally, yes.
I'm going to try to share my screen, and Mr. Chairman, members of the commission, please let me know if you are unable to see it, and I'll certainly try to fix it. So what I'm showing here is Exhibit A to the application.
Attorney Hall,
And, yes, sir.
if you could expand the document.
Thank you very much.
Is that better?
Yes, sir.
Great. Now, Mr. Sorensen, you may be aware of this, and I will go ahead and admit that this was an issue that the company had previously agreed needed to be addressed. I don't think it has been, so you can stop me anytime if you believe it has. Can you read the highlighted section, please?
I'm not sure I can.
Okay. Well, how about I read it, and we'll just subject to check, see if you agree. It states, bills issued for monthly sewer service provided during the 36-month period beginning May 14th, 2019 shall be reduced 34 cents per single family equivalent for commercial customers. Bills issued for service provided from and after that 36-month period will be at the full rate shown above unless a different rate is approved by the Public Service Commission after the effective date of this rate schedule. Does that sound at least generally familiar to you?
Mr. Chairman,
Attorney Tarini,
can I just ask Mr. Hall to email this exhibit to the parties? I think it'll make it easier for everybody.
It's the application. It is Exhibit A to your application.
please proceed, Attorney Hall. The objection is withdrawn.
Okay. And Mr. Sorensen, I guess I'll cut to the chase. Is it your understanding that this section where it says 34 cents per single family equivalent for commercial customers is an error? And that it should state instead of commercial customers, should state for residential customers and mobile home customers. In addition to commercial customers.
Right. I believe that that would be for all customers, residential, mobile home, and commercial, based on their EDUs, or equivalent residential connection amount.
Okay. And that's my understanding as well. Can you commit to that the company will revise that language at some point during this case?
Yeah, I think we can do that.
Okay, great. Thank you. And I'm not going to try to share my screen again. If you would like me to confirm any statement I read from your testimony, please let me know, and I will certainly do it. But I think I only have maybe one or two statements, so we can maybe avoid any screen sharing fiascos. But on page 5, lines 9 through 11 of your rebuttal testimony, you state, if the commission accepts Mr. Garrett's or Mr. Rothschild's recommended ROEs, it will neither allow PWR to earn a fair and reasonable return on its investment relative to other regulated utilities, nor will PWR be able to attract capital. Does that sound accurate?
It does.
And do you provide any evidence that shows the return on investment provided by other regulated utilities is higher than Mr. Garrett's or Mr. Rothschild's recommended ROEs?
I believe my table in South Carolina, or what? I'm not sure I understand the question.
And do you provide any evidence that shows the return that other regulated utilities receive higher ROEs than Mr. Rothschild and Mr. Garrett recommended?
I believe so. In the table on the previous page, I list the ROEs for our affiliate companies and the ROEs that the utilities are granted the opportunity to earn from the various commissions in other areas. And I can read those again, but every one of those is above 9.0%.
And those are all affiliates of PWR, correct?
Correct.
Okay. So are you saying that the commission should determine the cost of equity and an appropriate authorized ROE for PWR simply based on ROEs issued in other jurisdictions?
I think it's something that the commission has the power to use its own judgment and make its own decision, but these are relevant issues, I think, and are what's going on in the world. And it's my opinion that the commission would like to be informed. I know I would if I were on the commission of what other utilities are being authorized to earn.
But if the commission relied simply on what other affiliates of PWR are earning, those ROEs would not reflect current market conditions, would they?
Well, that's a question for the bench, but I think the ROEs that I've listed, some of them are from this past summer, some of them are from this past spring, and one from last year and one from the year before. These are pretty recent hearings.
And do you know, did those commissions presume that those were based on market conditions?
I can't speak for those commissions.
Okay. Do you know, our authorized ROEs are applied to the portion of rate base funded by equity, correct?
Yes.
And rate base is based on the original cost of investment less depreciation, correct?
Among other ways of calculation, but I think generally.
Okay. And an authorized ROE is not applied to the market value of a utility company's equity, is that correct?
It can be.
It can be applied to the market value?
There are numerous ways of valuing rate base, and original cost less depreciation is one that you've named. There's also replacement cost new less depreciation, which is a method that is allowed in several jurisdictions as a means of calculating rate base. And I think in those instances, I think that would be a market cost.
Okay. Have you determined do you know the market price of the other affiliate companies that you listed?
Not here this morning.
So it's not included in your testimony?
It is not.
And did you determine the market return? I'm sorry, excuse me. Are you aware of any of the valuations of other publicly traded water utility stocks?
Am I aware of the valuation of publicly traded stocks?
Yes, of other water utilities.
I'm aware that there are other water utilities that are publicly traded.
And you're not aware of any valuations of those companies?
I could not speak to those.
Are you aware that the market price of water utility stocks is typically 3.5 and 4 times the original cost of the investment?
I could not speak to those.
So PWR has been granted a monopoly territory, is that correct?
We have a service territory that we are authorized to serve.
And no other company can offer sewer service in that territory, can they?
That's correct.
And I believe you testified
Chairman,
before you believe PWR.
I object.
Yes, sir. Please state the basis of your objection.
I believe the foundation of Mr. Hall's question is incorrect. While PWR has been assigned a service territory, the only thing that would prevent another utility from entering its service territory would be if it unreasonably interferes with its operations. We don't have exclusive service territories for water and sewer utilities.
Mr. Chair, I was just asking the president of the company a question. Wanted his opinion.
Well, he shouldn't misstate the law if he's asking a question. And I don't think he did it intentionally, but I'm just making that point.
Attorney Hall, do you recognize the point that, I mean, obviously you wouldn't misstate the law intentionally. We all know that, but just note the objection. Please proceed.
Thank you. Mr. Sorts, I believe you testified earlier that you believe PWR is a good company, right?
I do.
Do you believe that it is fair to lower PWR's current authorized ROE since they have performed well?
I do not.
So should the ROE just continue to go up every year that PWR performs well?
Well, I think that obviously that's not my decision. I would argue that good performance, good customer service, and good community citizenship should count for something, and that in the face of consistent circumstances and all else being equal, I would think that you should at least be able to maintain what you're authorized to earn. I think there is a lot to be said for making a good decision early on and then maintaining that decision. I'm not advocating that returns should continue to increase infinitely. I don't think that would be appropriate.
Okay. PWR has an obligation to provide good service to its customers, right?
We strive to provide excellent service to all our customers, yes.
So, I mean, the fact that people can flush their toilets, that we don't have sewer leaks, that's doing your job, right?
Those are part of our that's part of our role, yes.
There's nothing exceptional about people being able to flush their toilets without our rivers being polluted, right? I mean, that is the essence of us being a sewer company, right?
A sewer company, like lots of utilities, has a myriad of challenges that occur daily, and Some of those are seen and known ahead of time. Some of them are unseen and unknown, and are, you know, caused by events that are beyond the utility's control. I think there are lots of you know, reasons to be proud of providing good service and succeeding in that, in spite of the challenges that come from time to time. Heavy storms, rain, electrical power, electrical outages, blockages. You know, there are all sorts of challenges that wastewater utilities in particular deal with on a day-to-day basis. Flushable wipes, and let me take this opportunity to thank everyone for not flushing flushable wipes, and the challenges that creates to pumps and lines and within the facility are sizable. So yes, it is the target, it is the goal to have lines run free and you know, service continue, but there's always circumstances that are working against you.
Certainly, and I appreciate that. I didn't mean to diminish the effort it takes to accomplish that. Just wanted to establish that is the service you're providing. So we've established you're not an ROE witness. That's correct, right?
Yes, we've established that.
So when you say that other witnesses' proposed ROEs are not fair and reasonable, that's just your personal opinion, right?
That is my opinion as president of this company, that those would not be appropriate for my business.
Where does PWR's capital come from?
Our capital is provided to the utility through the parent company.
Is that Southwest Water Company?
Yes.
Does anyone other than Southwest Water Company provide capital?
No.
And PWR doesn't have any formal debt agreements with Southwest Water Company, correct?
I would leave that to Mujib Hafiz and his testimony. As to formal documents, I don't believe that there are.
Okay. So I think we've established that Southwest Water Company acquired PWR in September of 2020. Is that correct?
That's correct.
And the current residential rate is $37.92 per month.
I believe so.
And that was approved in 2018.
I'm sorry. I'm sorry.
$37.92, is that the current rate?
I believe so, and I think that's before the reduction that you mentioned earlier. I think the rate is $37.58. Is that correct?
That sounds right. If you subtract 34 cents.
Yep.
Yes, sir. Are you familiar with the rates PWR's customers paid prior to the acquisition by Southwest Water Company? Or I'm sorry, prior to 2018?
I'm not.
Okay. Would it surprise you that those rates were $24 and $29 in 2014?
No.
Would it surprise you that in 2013, the Alpine Territory customers were paying $16.75 a month?
Though, you know, rates do not generally surprise me. I think that you know, you look at those rates, and what is surprising is how low they are, especially in the light of, you know, surrounding utilities and what those rates, including the municipalities, are charging today. You know, PWR with the rates we've proposed are still on the very low end of the area rates. So, you know, am I surprised? I'm not surprised, but those are very low rates.
So I guess it wouldn't surprise you then that PWR's customers' rates have more than doubled in less than 10 years?
Not necessarily, and especially when you look at, you know, doubling a small number, you know, that's a small increase.
Okay. Who do you report to?
I
within the
report.
company.
I report to the Chief Operating Officer.
Who does the chief operating officer report to?
He reports to the Chief Executive Officer, who
Does
reports to the Board of Directors.
Does any other entity own Southwest Water Company?
Southwest Water Company has shareholders.
But no other entity that you're aware of?
No other utility company. We're not part of a larger wastewater utility beyond Southwest Water.
Or any other type of company? Is Southwest Water Company a, for lack of a better word, subsidiary or of another company?
We are not a subsidiary of another company. We're not publicly traded. We have stable shareholders.
Have you heard of the Infrastructure Investments Fund?
I have.
From your work experience with PWR or Southwest Water Company?
Yes.
And what is there a relationship between the Infrastructure Investments Fund and Southwest Water Company or PWR?
Infrastructure Investments Fund is the shareholder of Southwest Water Company.
And do any of its affiliates sit on the board of Southwest Water Company?
Mr. Chairman, I object on the basis of relevance. We're now talking about.
Sustained.
Thank you.
May I offer an explanation, Mr. Chairman? No.
Yes, sir. Go right ahead.
There's been a lot of testimony in this matter that PWR is a small company and therefore are entitled to certain adjustments due to their risk. What he has established already by the questions I have asked is that there is a large group of investors that essentially are controlling members of Southwest Water Company. So it's very relevant to whether PWR is a small company and risk investments due to their small size.
Mr. Chairman, even with the stricken matter, this is beyond the scope of anything Mr. Sorensen's testified to. It may be appropriate for Mr. Mowell, but it's not. Mr. Sorensen hadn't given any testimony about a small company adjustment.
Mr. Sorensen is the president of the company and has already testified that they will be unable to raise capital, that they will have, it's unfair to them. Other companies, get higher ROEs. So I'm just trying to establish the fairness. I believe is very relevant.
Understood. The objection is sustained. Please move on.
Okay. Mr. Sorensen, have you heard of JP Morgan?
I'm sorry? Yes, I've heard of JP Morgan, yes.
Would it surprise you if you learned that the Infrastructure Investments Fund is controlled by JP Morgan?
Mr. Chairman, objection. Same objection. I'm just not going to even restate it.
It's a different company. We've already established he is familiar with the Infrastructure Investments Fund. He answered that question. I have two more questions.
So, Attorney Tarini, I understood your last objection. What's the objection to the current question? Is it relevance or?
It's the same objection. I mean, you sustained, he was asking irrelevant questions about the ownership of the parent company of the utility. Now he's asking irrelevant questions about the relationship between the shareholder of the utility and an investment bank. I just, seems pretty far afield.
All right. I'm going to allow counsel to ask and require the witness to answer that question if he can. That objection is overruled.
Thank you. Mr. Sorensen, so again, the question was, would it surprise you if you learned the Infrastructure Investments Fund is controlled by JP Morgan?
I believe the Infrastructure Investment Fund is advised by JP Morgan, yes.
Would Southwest Water Company be a good investment for JP Morgan?
I like the water business. But I would wave my flag.
Thank you. That's all the questions I have.
All right. It is 11:40. I would imagine if there's any more cross-examination, it would take longer than 5 minutes. But let me just check in with the Office of Regulatory Staff. Do you have any cross-examination?
I do, Mr. Chairman. It may take a little longer than 5 minutes.
Okay. All right. We're going to go ahead and break here, and we'll be back at 1 o'clock.